I wouldn't exactly call it a court filing, and she hasn't paid a filing fee. She emailed a motion to stay eviction and motion to set aside judgment, motion to stay execution of judgment, motion to set aside vacate judgment, on a number of things in an email. She then also today dropped off a bunch of stuff to the clerk a short time ago, which she's still trying to get date stamped and scanned in, so I haven't seen it yet. The defendant is here in pro per. Legal aid will not be representing the defendant. Megan Bauer told me or us that she would not be representing this defendant and that they did not accept her as a client. So she's in pro per. We had a first hearing on November 7th. We had, me being the court, had some confusion about how much was actually due. There were issues about how costs were calculated, what were late fees, what were utilities. So we rescheduled the matter, as we always do, for a second hearing. And that was heard on the 14th of November. And the parties were placed under oath, and I took testimony and came up with a figure that the amount owed. This is a demand for non-payment of rent, not termination of tenancy. I found that the amount owed was $2,752.69, $169.84, and cost for a total of $2,922.53, I think it is. As I indicated, it is a non-payment of rent case, and it allows removal of the trailer. The defendant has filed a bunch of stuff, not paid the motion fee, and asked me to stay these proceedings. The defendant has raised a number of issues here that I don't think were raised before. Ms. Early, what are you asking me to do?
Well, their math isn't mathing. I did make 2 payments that I was ultimately told by them that did not go through, but they did go through my bank. So I ended up paying them, and I don't have the paper in front of me, so I don't have the exact figure. It was over $2,000 some, which leaves me a credit of $100 for the month of November. And there's in their system, when I sign on, it even shows that, and it shows that I made the payments also. I did include some of my bank statements also. There's a lot in there, and I'm sorry, I try to keep it minimal.
We took testimony under oath. Ms. DeCenzo is here, and the manager, Jessica, is also here. Jeshua.
Records even show it, like the bills that they dropped off on my door, and they didn't apply the accounts to my account. And the thing that's really disturbing to me is I tried to get a hold of Ms. DeCenzo yesterday. I think I missed her call. I have 2 portals that I can log into. One of them shows that I didn't pay, and the other one shows that I have paid. Now, why I have 2 different portals from them, I have no idea why, but they're completely different login information. She did have me set up a new account. I think it was in August when I did pay. I paid August 8th, and I think it was 14th possibly.
Your Honor, if I may, we're covering old ground here.
Yes.
This was argued on the 14th. As was noted on the 14th, there were 2 payments that were made and returned to NSF. And you noted that as you calculated the amount due. As far as today is concerned, obviously I didn't have an opportunity to get a response in, and I haven't seen whatever was dropped off this morning.
Neither have I. It's a big pile of stuff that has been handed to me about 2 minutes ago.
So what I would say is, firstly, if there's a motion for stay, it should have been accompanied by 1 month's rent as a bond. If there was no filing fee paid for the motion, I'm guessing there was no month's rent deposited with the court. I would also indicate that what this seems to me, at least in part, would be a motion for reconsideration. And for that, the tenant defendant would have to show that there was a palpable error on the part of the court. And looking at what was sent by email, I did not see any kind of palpable error. She argues that she was somehow entitled to a public defender or legal aid to represent her. And I think we've established that certainly was not going to happen. in addition, she's making the same argument, it sounds like this afternoon, that she argued on the 14th. I would indicate to the court that at the time that the court entered the judgment and noted the payment deadline of the 24th, it indicated that it was not likely to sign any kind of order of eviction until probably December 1st, just because of the way the holiday broke. And in fact, with this motion having been filed, we have not yet submitted the order of eviction to the court. We're prepared to send it in as early as today, but the court's not going to get it or look at it until after the weekend. So there is still time for Ms. Zierle to move without having an extra month's rent added to her tab. I think the court handled everything properly on the 14th. It took extensive testimony from Ms. Zierle. It evaluated it. It credited her for some money that had been assessed because it felt that the late fees were too high. Therefore, the judgment amount was less than the amount that was showing on my client's ledger. And I see no basis at this time to revisit anything that the court did on the 14th.
May I speak?
Yes.
But you haven't seen what I have, and neither has he. I don't feel that I had another person to back me up as I needed, and I felt like I got railroaded. And I feel like what I do have needs to be looked at, and it needs to be considered no matter what was decided on the 14th. I did state when we first started that I filed that I needed some help because of an ADA accommodation, and that was under oath. And
I looked for
expected
that. I
things
couldn't
to
find it,
stop
but let me,
at that point.
this is a matter of paying your rent or not paying your rent.
Yes.
It's not an ADA. They're not terminating your tenancy for just cause. There are certainly accommodations we make for people with.
I just needed help speaking for
right.
myself.
Okay. I'll concede that. We had 2 hearings, lengthy. I blocked out a bunch of time. I knew it was going to take a long time. Then immediately after you file all this stuff like throwing spaghetti at a wall to see what it'll stick. You didn't pay a filing fee. You didn't file it properly. You just emailed it to the court. Now, you're not a lawyer. So this morning, like an hour before the hearing, you drop off all this stuff. It's your contention. You're not under oath. And I said, I don't believe you, but you're not under oath, that you've paid all the delinquent rent and you should actually have a credit.
It shows on the paper,
All
on their
right.
paperwork.
Show me in here, you find it, show me where it says you paid your rent.
Well, you look at these too. There's credits up there. They were never applied to my account. They just keep showing up and showing up and showing up. And here's the bank statements. And this is showing, it shows up like this when they've received a payment. And it's showing that I have a credit of $100 and some as of now. Even when I log in, like it won't let me even pay anything if I wanted to online. But I circled a bunch of things for Christy and I sent them back to her and I was like, it shows.
Then have a seat.
So there was 2 different things that happened with my bank.
Well, sit down, sit down. All right. Ms. DeCenzo testified under oath that they haven't received any money under any account since June. And I agreed with that. I substantially reduced the amount they were asking for by reducing late fees and some other things that were unclear. And I came up with that number after taking testimony. The way the trial works is you don't come in 4 days later and say, well, here's all the evidence I should have had at the trial. Plus, I can't make head nor tail of it.
I entrusted Meg
all right,
to.
so they want you to move your trailer. And I suspect you've done absolutely nothing to move your trailer. So what you want them to do is take your money and let you stay there.
I can't go anywhere. I'm halfway dead as we speak.
I don't
And she succeeded to an extent. Even if as I mentioned before, even if the order of eviction were submitted today, you're not going to see it until Monday. And what you choose to do with it at that point, what the court chooses to do with it is obviously up to the court's discretion. But as you have noted, Ms. Early is unhappy living there. She wants to continue living there, I guess, for free. And she should.
I'm not trying to
Stop. It's his turn to talk. Go ahead, Mr. Landman.
Yeah, and that's really all I have to say, Your Honor. I think that this was sort of a Hail Mary type of situation, and I don't see where the Hail Mary should be completed for a score.
I don't want to go, and I'm not trying to stall any time, and that's not what this was about. I thought I had someone to back me up in court. She had all my paperwork, and then when we returned the 14th, which I had spoke to her before the 14th, I thought she was going to be there with my paperwork to back me up. This is not me stalling. This is me trying to be fair and try to get a fair judgment.
And by she, you're talking about Meg Bauer from Legal Aid?
And I'm trying to do everything within the court's judgment and whatever you want to call it. I don't know the proceedings. I don't know what they are. I'm not a lawyer. All I've done is call and ask questions and try to see what I need to do. And I'm still lost as that goes. But I don't feel that I should have to leave. Their math is wrong. And I don't appreciate getting threatening phone calls from her either. And I don't know if you read that or not. And I'm not making that up.
Well, since I didn't see it until 1 minute ago, I guess I didn't see it. Who made threatening phone calls to you?
She did. She was laughing.
She who?
Ms. DeCenzo.
As of when?
Before court. Before the first hearing. They kept calling me like 3 weeks before court, asking me why I hadn't left yet, telling me I needed to sell, and if I didn't do this or that, I'm not gonna repeat any of it out loud.
Well, one factor, you need to be able to speak to each other. Mr. Landman's suggestion is that you would somehow transfer title of this to them and move.
I don't even know that I have it. I'm not sure whose name it is anymore because all that stuff was stolen out of my house. I don't even know if my car is in my name anymore. To be honest with you.
Motion to stay is denied. Motion to set aside the judgment is denied.
Which I guess in child kindergarten terms, I'm going to need you to explain to me what that means.
Means they're going to move your trailer off of there unless you agree to move it or transfer it to them.
So
they cannot move you out of the trailer. They can't have the sheriff come move you and your stuff out. This isn't that kind of an order.
So I'm essentially going to be homeless because I can't get a loan and I cannot get help. I've already tried to do all of that. That's cool. Happy Thanksgiving.
Perhaps.
She told me she would do this to me and she would make sure that that happened.
My goal isn't to make you homeless. My goal is to try to follow the law. And they filed this. They filed all the proper procedures. I'm allowing to do this, as I indicated. I wish they'd done it differently, but I gave the order that I gave. I took testimony under oath. Legal Aid is not representing you. They indicated then, they've indicated since they will not be filing an appearance in this case.
A lot of times I see you, I think you might need a lawyer for this. You didn't even offer me that. I don't know what I'm doing. All I know is I paid what I paid and they are trying to get more out of me than what I've paid. They're trying to get me double. And if you look through the bills that they personally gave me themselves and hung on my door, it literally says I paid them.
Well, the sworn testimony was no payment has been made since June of 2025. And that's the finding that I made.
I paid in August.
I greatly reduced the amount owed. I believe their version more than I believe yours.
It's not a matter of whatever you believe me. It's what is on paper there in front of you.
And I don't want to argue about it anymore. You're going to have to prepare.
I can't even make a payment.
You're going to
have a credit of $100.
I did not make that finding.
All the paperwork is in front of you. I don't enjoy. The only reason why I haven't paid them is because I paid them twice. And if you look through that fudgery of clown paperwork, it's not funny. Like, I don't know why they're trying to do this. Jesus knows, or Jessica, or Jessie, or whatever you want to call her. She knows I paid. I know she knows. I know she knows I got it. I'm concerned that they should do an audit on the whole trailer park because I guess I'm not the first person this has happened to. I've even asked her how much my rent is supposed to be because I think I'm paying a ridiculous amount of rent for living there opposed to other people. Why is that? Why don't I have a garbage can? Why was mine taken away and nobody else's? Like, this is just all retaliatory.
All right. They prevailed on the 14th, and I stand by that original ruling. So your options are to move your stuff out and leave your trailer there, move your trailer to somewhere, or negotiate some sort of sale or transfer to the park for
But
the,
yeah, they offered me $500 in my keys.
I don't know the answer to that. I don't know how much the trailer's worth. In fact, I don't even know if you have the right to transfer the title to it.
I wish you would take the time and just really look through that stack. I know that you are.
I've made my ruling and I've stand by
You
it.
did, and you made your ruling on the 14th, and I told you at the beginning of that I needed help. I had filed an ADA for a reason.
You didn't
I
file
cannot,
an
I
ADA.
did,
I
and I
made-
did before that court
All
date,
right.
and I told you under oath, and at that point, all proceedings should have stopped.
For what?
It's part of
Someone
the
to-
law. It's part of my rights.
All right, then you
And I
can
felt
appeal, you can
railroaded.
appeal this to the circuit court and ask for a stay there. I don't think he'll grant one. They don't want you there.
don't
If you
wanna be
had a
there,
big
but
pile
I'm-
of money, you could pay it all. And I'd
I
have to
probably have a
accept-
year left in
Well,
my life.
here's one, I told you how much you owed. Pay it.
I'd rather pay a lawyer and have them look at that stuff than pay them.
Well, that's up to you. I told you in clear English that through November, now shortly, December will be due. I told you after a hearing, you owe $2,752.69 in rent and a court cost of
I paid
$169.84.
in August. I had $3,000 in my
All
account
right.
in August, and then I paid them, and I have
Well,
like
then-
500 left.
You
Where'd
owe
it go?
$2,922.53. Mr. Landman, she gave all this stuff to us at 10 to 1. We scanned it. I'll send it to you, but
Your
please
Honor, that's
escort
not
us early.
necessary. Your staff already has done so.
All right, thank you. That's the cure. Pay it. All right, you're good to go. I'd
Thank you,
suggest
Your
if
Honor.
you want to stay there, you pay them rather than a lawyer. Of course,
But it
December's
sounds
rent.
like I paid them and I'm still not staying.
Well, if you pay them, you get to stay. That's pretty straightforward. You'll just under $3,000 through November. If you pay them rather than a lawyer, then your rent is current. I made a finding on how much the rent was due.
Well, I'm willing to bet that.
All right, please escort her out. I don't have
I don't
anything
know
else
how
to
to-
say. I don't want to
Can I
argue
get my
about the same thing.
paperwork
over
back?
and over.
Is what I want to ask.
Well, you file it with the court. Well, you did scan it, so I guess I'll give it back to you.
Okay.
Show that it
I
was,
mean, I didn't make a million copies of everything. I'm not violent. There's no need to be
All right.
I just wanna
You're
know if I
free
can
to
have my
go.
paperwork back.
Thank you, Your Honor. Have a happy Thanksgiving.
all right, thank you.
Okay.
Well, Ms. DeCenzo is waving her arms and she's muted.
I
That was not a
apologize.
good answer to that question, but that's my ruling and I'll stand by it. And I wish you would consider filing termination of tenancy, wrongful, just cause terminations in these cases. It'd make our life easier.
The problem,
guys
Your
can-
Honor, is that in order to fall under the just cause statute, when the tenant is behind in their rent, you have to have filed on them 3 or more times in the course of a year.
Yes, 3 times in a 12-month period.
Right.
That's the
So-
way everybody used to do it.
So
Uh,
the,